Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello. It is Supreme Court season, and I have one from the court and 4 others, totaling 5. Lots of remands, too. Before I get to the cases, here's this from the American Immigration Council, or AIC. According to AIC, and lots of reporting, a federal court this week blocked Section 10 of Florida's draconian anti-immigrant law, Senate Bill 1718. The ACLU, Americans for Immigrant Justice, AIC, and the Southern Poverty Law Center successfully sought the preliminary injunction on behalf of the Farm Worker Association of Florida and various impacted individuals. This Florida bill made it a crime to drive an immigrant who entered the United States without inspection into Florida. It, quote, put thousands of Floridians and residents of other states, both citizens and non-citizens alike, at risk of being arrested, charged, and prosecuted with a felony for transporting a vaguely defined category of immigrants into Florida, even for simple acts such as driving a family member to a doctor's appointment or going on a family vacation, end quote. The federal court held that the Florida law unconstitutionally inserts the state into immigration enforcement and could cause irreparable harm to families, organizations, and communities. And I believe that AIC and others recently sued to enjoin a similar law in Iowa. It looks like copycat laws are springing up in certain states all over the country, much like what's happening with abortion-adjacent things post-Dobbs. It would appear that the states believe that, like in Dobbs, simply because the composition of the Supreme Court has changed, that the court is willing to ignore stare decisis and overturn what is in this case its only decade-old Arizona v. United States decision. We'll see if the court takes the bait. Also this week, a split Ninth Circuit denied a request from the states of Alabama, Kansas, Georgia, Louisiana, and West Virginia to intervene in the Trump transit ban era lawsuit that apparently is currently under settlement negotiations. The states believed that their residents had a specific and significant interest in the U.S. barring asylum applicants from seeking safety in our country due solely to the fact that they had traveled through Mexico on their way to get here. To paraphrase, of course. But alas, they cannot intervene. Wonder what's happening with that settlement, particularly as I believe that the Biden administration is considering similar regulations of its own. And I believe that the Biden administration is now defending a parallel challenge to its own similar rules. Regulation season, as well as Supreme Court season, is truly upon us as the November election approaches. I suspect the agencies will soon be quite active finalizing new regs. We'll see what they say. And here is what the court said this week. Starting off with Brown v. United States, published by the U.S. Supreme Court on May 23, 2024. Here comes the Supreme Court. I always start with the Supreme Court when I have occasion, because I still want to respect the court. But you make it so hard sometimes, SCOTUS. This one in particular is a long, complicated case about controlled substance offenses and the Armed Career Criminal Act, without any direct connection to immigration, authored by Justice Alito. So I'm not going to go too deep into it. Here's why it's important. The ACCA, like immigration, punishes people if they received certain drug convictions in the past. As relevant here in the ACCA context, you get more time in prison for your current federal conviction if you have 3 past convictions that qualify as a, quote, serious drug offense, end quote. So like with immigration, you have to match up the state definition of the drug offense with a federal drug definition. Here, a serious drug offense. For both purposes, you're matching up with the Federal Controlled Substance Act. And for both, the categorical approach applies. But what happens when the drug at issue was on the federal schedule when the defendant possessed or trafficked in it, but it was later removed? That is, what happens when the state crime matches the definition of a serious drug offense at the time of conviction, but at the time that the federal prosecutors are trying to enhance a different conviction many years later, it no longer qualifies as a serious drug offense because now the feds no longer criminalize the federal drug, or they do so underbroad. Well, according to the Supreme Court, quote, a state drug conviction counts as an ACCA predicate if it involved a drug on the federal schedules at the time of that conviction, end quote. Even if later, at the time of enhancement, it did not. I'm not going to get into all the ways and the whys, but as Justice Alito and the majority tell it, the ACCA involves a, quote, backward-looking examination, end quote, which requires, quote, sentencing courts to examine the law as it was when the defendant violated it, even if that law is subsequently amended, end quote. That is the federal definition and the matching of a serious drug offense. Justice Alito believes it important that the conduct at issue here, drugs, and that can lead to ACCA enhancements, quote, reveals that the defendant previously engaged in illegal conduct that created a dangerous risk of violence with law enforcement, end quote. That risk, concerned Justice Alito states, doesn't go away just because the law is later amended. Here that means that the defendant's federal sentences can be enhanced for their prior serious drug offenses. Justice Jackson dissented, joined by Justice Kagan and Justice Gorsuch in part. I didn't review their dissent. Maybe there are some nuggets in there that could be mined later if it comes up in an ICE brief. Because of course, what does this all mean for immigration? Again, the holding, quote, a state drug conviction counts as an ACCA predicate if it involved the drug on the federal schedules at the time of that conviction, end quote. Even if later, the federal schedule was amended and it doesn't anymore. The word immigration isn't used once in this entire decision. And maybe, truly, the ACCA is distinguishable. There are, after all, many parts of the ACCA analysis and many statutes and other rules involved that are different from immigration. I'm no expert, but it is the same categorical approach. Now, my understanding in the immigration realm has always been that you compare the definition of the state offense, be it drugs or otherwise, that was used at the time of conviction, with the definition of the federal removable offense being used at the time of the merits hearing. That's different than what the Supreme Court seems to be saying here. I don't understand how it could possibly be the other way around in immigration. But I bet ICE and the private bar are going to try, depending on how it helps or hurts non-citizens. I truly, however, don't see how that would work or be appropriate, at least in the immigration context. What even is a change in federal law for immigration purposes? It's easier to imagine when you're just referencing drugs with the Federal Controlled Substance Act, but would it also say apply to case law changes that change the definition of the federal removable offense, like the 11th Circuit aggravated felony decision that I'm going to do at the end of this episode? That can't be the case. It can't be the case that a non-citizen is removable for a conviction that occurred in 2020, when a circuit said that the conduct or the conviction isn't removable, but didn't say it until 2021, and the removal proceedings occurred in 2022. So why then would the CSA be any different? You're still talking about the federal definition, in our case, of a removable offense. Watch out though, at least on the drug stuff from now on, and at least if your argument is based, in the somewhat unlikely event, on the fact that the CSA changed in between the commission or conviction that your client received and removal proceedings. Finally, and as an aside, and I know I must be wrong here, but one of the issues in this case involved Pennsylvania marijuana. Justice Alito says that up until 2018, Pennsylvania and the CSA criminalized possession of the entire marijuana plant, but that Pennsylvania became overbroad when in 2018 Congress narrowed and amended the law to exempt certain forms of hemp. But see, I thought that, a la Said, it was always the case that the feds exempted the seeds and stems and other non-smokable portions of the marijuana plant. So wasn't Pennsylvania always overbroad? Again, I'm sure I'm missing something, and I should go back and read Said, but I am slightly worried. That's the possible bad. Here's some possible good. Another defendant in this case had a Florida cocaine conviction from 1998 and 2004. Those matched the federal definition of cocaine at the time, explained the Supreme Court, quote, "But in 2015, the federal government legalized a radioactive cocaine derivative called 1,2,3-ioflopane. That is the active pharmaceutical ingredients in a drug used to diagnose patients who are suspected to have Parkinson's disease." So when the defendant committed his federal offense that's being enhanced, the federal and Florida definitions were no longer a categorical match, end quote. Did the Supreme Court just say that Florida cocaine is broader than the federal definition beginning in 2015? Or are these different definitions being used for the ACCA? Worth a look into, listeners. And that is Brown v. United States. Next up is a matter of MNI, published by the BIA. This case is about choice of law, that is, the circuit law that applies in a removal proceeding. It is the natural follow-up to matter of Garcia, episode 152, and relies on that decision heavily. And it's just an absolute maze. The respondent here is from Morocco, and he was detained at an immigration detention facility located in Pennsylvania throughout the course of these proceedings. Pennsylvania is in the Third Circuit Court of Appeals. Proceedings began, however, in the Cleveland Immigration Court. That's where ICE filed the notice to appear. Ohio is in the Sixth Circuit. The NTA was filed in Cleveland because, I guess, the detention facility doesn't have an immigration court connected to it, and at the time, Cleveland was the designated administrative court that was hearing cases where the non-citizen was detained at this facility in Moshannon, Pennsylvania. Making it even crazier, the immigration judge hearing all of this was sitting in Richmond, Virginia, one of the new immigration adjudication centers that EOIR has created that I believe is filled with judges and attorney advisors but who never have non-citizens appear before them physically and instead simply hear cases over video or sometimes even decide cases that have been heard by different IJs sitting elsewhere. Virginia, of course, is in the Fourth Circuit. Then, although venue was never technically changed from Cleveland, quote, internal agency records reflect that the Elizabeth, New Jersey Immigration Court, which is located within the Third Circuit, was assigned administrative control over the respondent's case by an internal administrative process. However, no corresponding immigration judge order was contemporaneously issued to the parties reflecting this change, end quote. So internally, the whole matter went from Cleveland to Elizabeth, New Jersey, even though the IJ is in Richmond, Virginia, and the respondent is in none of these courts. Later on, the respondent received a notice for his individual hearing. That merits hearing would be via WebEx, the notice explained, I guess before the Virginia Adjudication Center, which is in the Fourth Circuit. But the notice was issued by the Elizabeth Immigration Court, Third Circuit. But the notice listed the address of the Cleveland Immigration Court as the hearing location, Sixth Circuit. And respondent is sitting in the Third Circuit. The respondent then filed a motion to change venue, arguing that venue actually lay with the Cleveland Immigration Court because neither party had filed a motion to change venue to the Elizabeth Immigration Court. A different IJ denied that motion, holding that Elizabeth now had jurisdiction over the Moshannon Valley Processing Center, which I do think is what EOIR did behind the scenes. In fairness, both Elizabeth and the respondent are physically in the Third Circuit. The respondent's briefs, though, then argued that Sixth Circuit precedent applied, but the IJ applied Third Circuit precedent and denied deferral of removal under the Convention Against Torture, which appears to be the only relief or protection at issue in this case. What a mess. The BIA tried to clean it up, and agreed with the respondent. Sixth Circuit law should have applied rather than Third Circuit. Matter of Garcia itself holds that, quote, the controlling circuit law in immigration court for choice of law purposes is the law governing the geographic location of the immigration court where venue lies, namely where jurisdiction vests and proceedings commence upon the filing of a charging document, and will only change if an immigration judge subsequently grants a change of venue to another immigration court, end quote. So that didn't happen here. No venue change from Cleveland, remember? Now, Matter of Garcia also discusses, quote, administrative control courts, end quote. But Garcia apparently explained that while they're important for choice of law purposes, they're not dispositive. EOIR might change the governing administrative control court for a variety of internal bureaucratic reasons, but, quote, the agency's administrative control designation does not replace nor circumvent the regulatory requirements for a change of venue, end quote. EOIR cannot, quote, effectuate a venue change unilaterally from the immigration court where jurisdiction vested to a newly designated immigration court, end quote. In layman's terms, the IJ where the NTA was filed has to grant a change of venue, or else the governing law remains the court and the circuit where the NTA was filed initiating proceedings. And by the way, IJs can't change venue on their own, explained the BIA. They need a motion from the parties. Is that the same rule even where the non-citizen was detained and was then released? Gotta look into that, because that's definitely not been my experience in that narrow circumstance. Anyway, the BIA believes that this is the most fair rule. Quote, because venue may only be altered on the party's initiative for good cause shown, and not by the agency for its administrative needs, linking choice of law with venue gives the parties notice of the law to be applied and an opportunity to mount a challenge when a change affecting the applicable law is proposed, end quote. So again, applied here, the NTA was filed with the Cleveland court in the Sixth Circuit, and a motion to change venue was never granted out of the Sixth. The NTA, which appears to have been sufficient, by the way, similarly instructed that the respondent appear before the Cleveland court, albeit virtually, I assume. This latter fact, where the NTA, or I guess first notice of hearing, told the respondent to appear, is also relevant, by the way, for all of this per Matter of Garcia. The internal agency transferred to the Elizabeth Court for administrative purposes, a court in the Third Circuit, had no effect on the circuit law to apply in this case. That motion to change venue back to the Sixth Circuit never actually needed to be filed by the respondent in the first place. The Sixth Circuit was always the applicable circuit. What to do in this case, though? Well, quote, errors in applying choice of law by IJs do not automatically necessitate a remand when the record contains sufficient factual findings and analysis allowing the board to engage in meaningful review of the record, end quote. That is, the BIA believes that it can apply Sixth Circuit precedent on its own to the facts found by the IJ, even though the IJ applied Third Circuit precedent. The BIA did not do so here, though, because it believes that the factual record needs to be more fully developed. So remanded. Congratulations, Jennifer C. Bade, for respondent. Gotta note, though, as I think I did a bit in Garcia. The BIA expressly reasons in this decision that it believes this scenario best protects a non-citizen's interests in this WebEx virtual world that we now increasingly live in. But the way precedent has developed on this issue means that a future administration that is not operating in good faith can file an NTA in an immigration court located in, say, the Fifth Circuit, even if the non-citizen is immediately released from the Fifth, or even, I suppose, if the non-citizen was never even physically present in the Fifth Circuit in the first place. EOIR could then have an IJ sitting in an adjudication center, or theoretically even in some other court, hear and decide the matter, even though no one is in the Fifth Circuit, all the while applying, say, Fifth Circuit precedent to the case. if the non-citizen never files a motion to change venue, or even if they do and the IJ decides in their broad discretion to deny it, Fifth Circuit precedent would forever apply, at least at the removal proceedings level. Though I suppose the same or similar concerns can be said of anything that the BIA chooses to do on this complicated choice of law question. After all, if you're assuming an administration that's not operating in good faith, well, you're kind of in trouble no matter what. And that is matter of MNI. I know you're ready for some asylum by this point. So we have Tulung v. Garland, published by the First Circuit on May 21st, 2024. This case is actually technically about motions to reopen. And just like last week's First Circuit decision, it regards Christians of Chinese descent in Indonesia. The Tulung family fits that description and fled Indonesia in 2004, quote, fearing persecution, end quote, on tourist visas. An immigration judge denied their asylum claims, as did the First Circuit, eventually. 2 years later, the BIA denied a change country condition motion to reopen. Then in 2020, the Tulungs filed another one, which the BIA also denied. Then in 2022, the Tulungs filed a third motion to reopen. They also filed a motion to reconsider the second motion to reopen and a motion to amend that second motion to reopen. All of that was denied, and now it's all before the First Circuit. The First Circuit affirmed the BIA in part, but also remanded. Because it seems here that the BIA made the same mistake that the BIA made in Abdullahad v. Garland, that Sixth Circuit decision from episode 207. The BIA didn't even reach the question of whether the Tulungs were prima facie eligible for asylum because the BIA didn't believe that they had provided new, previously unavailable and material evidence of changed country conditions in their third motion to reopen. The First Circuit doesn't appear to have a problem with that legal tactic in the abstract. That is, not even getting to prima facie eligibility if new material evidence isn't submitted. The problem is that in doing so, like in Abdullahad, the BIA believed that the Tulungs had simply provided evidence that was cumulative of their second motion to reopen. And that's the problem. Quote, we have stated time and again that the BIA must compare the evidence of country conditions submitted with a motion to reopen to those that existed at the time of the merits hearing, end quote. Emphasis by the court. The point of comparison of evidence is not with that submitted with a previous motion to reopen, but rather always remains with the evidence submitted at the merits hearing. So believing that evidence submitted was cumulative as compared to previous changed country condition motions to reopen that was filed is not sufficient for the BIA or an IJ to deny a subsequent changed country condition motion to reopen. The BIA should be especially familiar with this requirement as it comes from BIA precedent, end quote. That is matter of SYG from 2007, something that Abdullahad also noted, I believe. If the new evidence, even if cumulative, shows a, quote, deterioration of country conditions, end quote, since the time of the merits hearing, all those years ago, and such that there might now be an asylum claim or withholding or CAT claim present, the BIA should reopen and remand. Quote, this principle holds for both first-time and subsequent motions to reopen, end quote. Flat out. Ooh, and how about this one? Quote, nor finally can the BIA disregard evidence because the evidence was available at the time of a prior motion to reopen. We require motions to reopen, including successive motions to reopen, to contain evidence that was unavailable at the time of the merits hearing, end quote. It seems that changed country condition motions to reopen really do offer multiple bites at the apple, highlighting the importance that the law and the circuits place on potentially meritorious claims for asylum and related relief and protection that arise while a non-citizen remains in the United States. Now, having been an attorney advisor and a law clerk, I personally can sympathize with the BIA and its staff attorneys' desire to compare successive motions to reopen and to deny them as cumulative. But, well, an increasing number of circuits are saying you can't do that based on the statute, regulations, and case law. So, remanded. That being said, the BIA's denial of that motion to reconsider the second motion to reopen and the motion to amend the second motion to reopen was proper. The unpublished motion to reopen decision grants reopening for Indonesian Christians included with the motion to reconsider, unpublished as they are, do not necessarily show legal error and do not require reconsideration of the denial of the second motion to reopen. Nor is a motion to amend really a proper procedural tool to do under these circumstances, explained the First Circuit. Rather, the proper thing to do is file a third motion to reopen due to changed country conditions, which is also what happened here, recall, and which is what is getting remanded. And so I guess it looks like the Tulungs got what they wanted. Remand for reconsideration of their changed country condition, motion to reopen. Meaning congratulations, William A. Hahn for petitioner. And that is Tulung v. Garland. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures. But let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines, it can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents and automates USCIS form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most, your clients and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. Next is Durakovic v. Garland, published by the 8th Circuit on May 20th, 2024. This case is about due process and nexus. The petitioners here are a husband and wife from Bosnia and Herzegovina. They are Bosnian Muslims, an ethnic and religious group otherwise known as Bosniaks. The husband, Mr. Durakovic, worked as a security officer in the early 2000s. He was also a confidential informant for the police, as his father was the chief of police. When his father retired in 2008, Mr. Durakovic stopped being an informant. But his past informing involved Serbian criminals, and from 2009 to 2012, he had 4 encounters with these criminals again. All of them were very, very scary, as described by the decision, involving entries into his home, attacks, threats, ethnic slurs against Muslims. It's pretty scary stuff as reported, all because of his past informant activities. Mr. Durakovic didn't report any of it because he thought it would make it all worse for him and his family. The family left Europe for the United States in search of safety in 2012 and applied for asylum in 2013. Their home in Bosnia was ransacked twice after they entered the United States, but also, quote, just 5 or 6 days before their hearing with the immigration judge. Mr. Durakovic's family, who were still in Bosnia and Herzegovina, told them that they were unaware of anyone still looking for Mr. Durakovic, end quote. Deemed credible, the IJ denied. As is so often the case, no nexus. The IJ believed that Mr. Durakovic was, quote, targeted for his cooperation with the police, not because of his Muslim faith, end quote. The immigration judge also determined that the petitioner's claimed particular social group of, quote, Bosniaks being persecuted for secretly helping the police investigate crime, end quote, was not a distinct social group within Bosnia. Similar rulings for cat protection. Things got hairy on appeal. The petitioners filed 2 motions to extend their briefing deadline, and the BIA denied them, both. And yet, Mr. Durakovic and his wife still got their BIA brief in on time. So it all must have happened within that 21-day period? That is crazy stressful. And I suspect it all happened during the last administration because now the BIA essentially grants one extension of the briefing schedule as a matter of course, if timely made. Anyway, the BIA affirmed the removal orders, as did the 8th Circuit. The petitioners first argued that the BIA denied them due process in denying those motions for extensions of the 21-day briefing deadline. And indeed, simply remarkable stuff, but also circumstances that were at one point all too common, quote, because of delays in the mailing of the transcripts and other documents. Mr. Durakovic's counsel claims she only had 7 days to draft and file her brief with the board, end quote. Thank God for e-service and e-filing. Now, for certain cases. And actually, I misspoke. It did not all go down during the prior administration. This was March 2021, very early into the current administration. I wonder why the BIA denied what appears to be credible briefing extension requests under such absurd circumstances, such as getting 2/3 of one's briefing period cut due to delays in the mail or potentially administrative issues at the BIA. Well, the BIA was relying on Trump-era regulations that were trying to make the life of immigration attorneys so brutal that many would flee the profession, as many did. But those regulations were enjoined a few months before the BIA denied the extension requests, it seems. That is, regulations that the Trump administration promulgated to make it really hard to get extensions of a 21-day briefing deadline at the BIA. Quote, thus, Mr. Durakovic argues that the BIA should have granted counsel a 21-day extension as a right under the old procedures, and its failure to do so prejudiced Mr. Durakovic because counsel had to scramble to review the record, ascertain the merits of a claim, and prepare an appellate brief, end quote, in less than 7 days. Maybe so, but the 8th Circuit doesn't see any prejudice from any BIA impropriety, the second prong required of a due process claim in removal proceedings. So really, the whole inquiry kind of gets wrapped up into the merits. But like if the argument is that your argument would have been better on the merits with a briefing extension, how can you really know whether there was prejudice, 8th Circuit? Well, here at least, the quote, petitioners do not identify any factual or legal argument that they failed to raise or develop on account of counsel not having enough time to review the record and write a brief, end quote. So no prejudice shown. In any event, reasoned the 8th Circuit, counsel could have been preparing an appellate brief even before receiving the briefing schedule and the transcript of what actually happened in court, something that no other attorneys have to think about because they have court reporters. Did I mention how e-filing in immigration court can't come soon enough for all cases? I do truly appreciate the progress we've made with ECAS. The 8th Circuit affirmed the BIA on the merits, too. No nexus for asylum. Although the Serbian criminals wore Christian identifying necklaces and used an anti-Muslim slur, quote, the Serbian criminals repeatedly referenced and explicitly stated they targeted Mr. Durakovic for being a police informant, end quote. And that, his informing, wasn't connected to his Muslim faith here. Religion is, of course, a protected ground, and a claim like that there was one thing intertwined with religion has won in other cases and in other circuits, but it's not present in this case, said the court. Moving on to withholding of removal, where, recall, the statute, the withholding statute, requires that a protected ground only be a reason, rather than one central reason, as is required by the asylum statute. If that's a lower nexus standard, as it is in the 9th and the 6th circuits, then religion might very well have satisfied the withholding of removal a reason nexus standard here. The 8th Circuit hasn't ruled on this issue yet, but the BIA has, of course, in matter of CTL. Smart Petition for Review Counsel argue that the 8th Circuit should not defer to CTL, and that it should agree with the 9th and the 6th Circuits. But alas, the petitioners didn't make that argument to the BIA, that is, I suppose, overrule CTL, so the 8th Circuit deemed the argument unexhausted. I personally almost always drop the argument in a footnote in the circuits that haven't addressed the issue yet for this very reason, but left open for another day in the 8th Circuit. And in this case, it meant that the 8th Circuit applied the same nexus standard to withholding as is applied in asylum, one central reason, which therefore tanked the petitioners for withholding of removal as well. The 8th Circuit also didn't see a Convention Against Torture claim and so summarily dispensed with the issue. And that is Durakovic v. Garland. Which brings us to Legger v. U.S. Attorney General, published by the 11th Circuit on May 20th, 2024. This case is about the always complicated world of aggravated felony sexual abuse of a minor offenses as defined in I&A Section 101A43A. Mr. Legger is an asylee from Haiti. Definitely one of the worst places to be in the world right now. In 2009, he was convicted of lewd and lascivious battery under Florida Statute Section 800.044, quote, an offense which the Florida Supreme Court has characterized as statutory rape, end quote. Heads up, the statute changed in 2022, so make sure you review that one and compare the new text carefully for later offenses. After a complicated procedural history, an IJ terminated Mr. Legger's asylee status, believing that the offense warranted termination of it, because it was a sexual abuse of a minor aggravated felony, and that additionally, Mr. Legger's marijuana possession offense also made him removable and made him inadmissible, presumably preventing him from adjusting to LPR status in immigration court under the Special Asylum Adjustment of Status provision at I&A Section 209? Unstated. But why else talk about inadmissibility, 11th Circuit? Remember, as weird as immigration law is, aggravated felonies don't per se make non-citizens inadmissible, but simple drug possession does. The BIA affirmed. The marijuana stuff, though, is totally wrong now. Saeed v. U.S. Attorney General in the 11th Circuit, authored by the same judge as this case is, if I'm not mistaken, and it unequivocally held that Florida's definition of marijuana is broader than the federal definition of marijuana because Florida criminalizes and includes, quote, parts of the marijuana plant that its federal counterpart does not, end quote. Saeed was published shortly after the BIA affirmed in this case, but now it's all dispensed with, pun intended, quite easily. My goodness, forget about that Schedule 3 stuff proposed by the Biden administration. The 11th and the 8th Circuits have done more for marijuana users than possibly any other federal actors. Go figure. And also, how does Justice Alito's discussion about Pennsylvania marijuana that I talked about at the top of the episode square with this? I really don't know. But anyway, at least for this case, and in the 11th Circuit, we're back where I said we were. Is Florida Statute Section 800.044 a sexual abuse of a minor aggravated felony? It is not, because of the Supreme Court's 2017 decision in Esquivel-Quintana v. Sessions, said the 11th Circuit. Now yes, if this conviction is an aggravated felony, it would require termination of asylum and make Mr. Legger removable. Unless actually he reverts back to an applicant for admission after asylum termination, thereby making the Section 212 inadmissibility provisions applicable rather than Section 237? Something I'm not 100% on. But let's just focus on asylum termination because it's simpler, and it definitely requires the aggravated felony analysis. Asylum can be terminated if an asylee is convicted of a particularly serious crime in the United States, and an aggravated felony is a particularly serious crime, per se, for asylum purposes. Ipso facto, this case is about aggravated felonies. The categorical approach applies to I&A Section 101A43A, as I believe it always does, at least in part, no matter the aggravated felony, as they all require a conviction, I believe. Sexual abuse of a minor definitely does. In this case, the 11th Circuit isn't sure if the statute is divisible or not, but applying the Supreme Court's Precedential Decision, quote, even if section 800.044 is divisible, such that the modified categorical approach might apply. The documents presented by the government at the removal proceedings do not shed any light on whether Mr. Legger violated subsection A or subsection B of the statute." End quote. Ah, burdens. That means for present purposes, either the whole statute meets the definition of a sexual abuse of a minor aggravated felony, or Mr. Legger wins. Like I said, he wins. The least culpable conduct criminalized by the statute in the 2008 version at issue was, quote, "consensual sexual activity between adolescents aged 12 to 15 with no minimum age for the perpetrator," end quote. It's essentially a statutory rape offense, and even minors can be charged with committing it, well, against other minors. Importantly, there is no age differential required between the perpetrator and the victim. Theoretically, explained the court, a 12-year-old could be convicted of engaging in sexual conduct with a 15-year-old. Okay, now lots of case law from the BIA and the 11th Circuit over the years have explained that the federal definition of sexual abuse of a minor does not actually require physical contact. Not so important here, but probably pretty important to the arguments made by Oil, because it seems that the 11th Circuit, quote, held that convictions under earlier versions of section 800.04 constituted the sexual abuse of a minor, end quote. But those cases were about the conduct argument, not the age differential, as they surely occurred pre-Esquivel-Quintana. So to the 11th Circuit, quote, "the prior precedent rule applies only to the actual holdings of prior decisions on issues that were actually decided by the earlier panel," end quote. Emphasis by the court. So that other 11th Circuit precedent that might actually be about this very statute doesn't bind, because it's not about the same or a very similar issue. It's not about the age differential. As an aside, and it's already a long episode anyway, but I'll take the aside, I cannot help but note that Judge Jordan was on the Edwards v. Attorney General of the U.S. panel discussed 11 weeks ago on episode 202, and he dissented, or he did like a dissent concurrence, on the refusal by that panel to apply older precedent in place of newer precedent on a retroactivity analysis that was clearly incorrect to Judge Jordan. I cannot help but believe that Judge Jordan is throwing serious judicial shade with all of this prior precedent discussion here, and that he has Edwards on his mind. Am I an uber nerd? Is this information that really has no practical place in my brain? Yes to both. Returning to the issue at point, and I'll get to Esquivel-Quintana in a sec. Relaying the history of the issue, the Ninth Circuit held in 2008 in Estrada Espinoza v. Mukasey, and Bonk no less, that the sexual abuse of a minor definition at section 11843A requires that the state statute require that the victim be between 12 and 16 years old and have an age differential of at least 4 years between the victim and the perpetrator. If the state statute doesn't require both of those things, it's not a sexual abuse of a minor aggravated felony. At least if it's a statutory rape-type crime, I believe. The Seventh Circuit, however, held in 2014 in the Velasco-Giron v. Holder decision that, quote, "a 4-year age differential between the perpetrator and the victim is not required," end quote. Something that aligns as well with BIA precedent. So we've already got a circuit split. Then came Esquivel-Quintana by the Supreme Court. The Supreme Court didn't even apply Chevron deference to the BIA's Rodriguez-Rodriguez decision and instead just used good old statutory interpretation. And it, like the Ninth Circuit, looked to the federal definitions of similar sexual abuse of a minor offenses at 18 U.S.C. section 2243 for guidance of what the federal generic offense required. Something that supports a 4-year age difference requirement, and something that the substantial dissent in Rodriguez-Rodriguez did as well. The Supreme Court then held that, quote, "in the context of statutory rape offenses that criminalize sexual intercourse based solely on the age of the participants, the generic federal definition of sexual abuse of a minor requires that the victim be younger than 16, end quote. Complicated enough yet? Remember, we're trying to figure out exactly what is the federal generic definition of a sexual abuse of a minor aggravated felony, and whether it must include a 4-year age differential between the victim and the perpetrator. Because the Florida offense definitely doesn't here. Muddying the waters even further, the 11th Circuit found a middle ground between the 9th and the 7th Circuit, but it leaned heavily in the 9th Circuit's direction. It followed the analytical framework of Esquivel-Quintana to hold that, quote, the generic federal definition of sexual abuse of a minor requires some age differential between the perpetrator and the victim, end quote. But frustratingly, the 11th Circuit held that the state crime must only require something, at least a 1-year age difference, and left for another day whether more is required. So in addition to Esquivel-Quintana, which again puts a rule for the federal definition on what the age of the victim must be, the 11th Circuit looked to other federal statutes, the Model Penal Code, state statutes in effect in 1996, and dictionary definitions for statutory rape from 96 and a bit later on. Plus, as the Supreme Court reasoned in Esquivel-Quintana, the sexual abuse of a minor ag fell at Section 11843A is right next to murder and rape. So it's supposed to cover pretty serious stuff, right? Quote, statutory rape, consisting of consensual sexual activity between adolescents between 12 and 15 who belong to the same protected age group, does not seem to us to be an especially egregious felony that falls into the same category as murder and rape, end quote. Wouldn't such reasoning support a per se 4-year requirement like the 9th Circuit does, 11th Circuit? Indeed, today, quote, even more states use an age differential of some kind in their statutory rape definition, end quote, than did in 1996. As does now even relevant federal definitions with the Adam Walsh Act. Boiling it all down, as so often happens in the 11th Circuit, it's actually even more of a narrow holding. Quote, in the context of statutory rape offenses that criminalize consensual sexual activity between adolescents who are 12 to 15 years old, the generic federal offense of sexual abuse of a minor requires that the perpetrator be at least 1 year older than the victim, end quote. There's the rule. But it won the day for Mr. Legger. His Florida offense does meet the Supreme Court's requirement of requiring that the victim be under 16, but it does not require any age differential between the victim and perpetrator. And of course, it criminalizes all that adolescent stuff. That makes the statute broader than the 11th Circuit's now definition of a sexual abuse of a minor aggravated felony, meaning it isn't an aggravated felony, meaning it isn't a particularly serious crime, meaning that Mr. Legger's asylee status was improperly terminated. And so, according to the always correct and totally never wrong website known as Facebook, congratulations to Mark Prada and his firm on this win. And by the way, if you're curious, according to Mr. Prada, Mr. Legger was 16 years old and the victim was 15 years old at the time of the incident. According to Mark, this aggravated felony interpretation is now in line with the BIA's precedent that such offenses are also not crimes involving moral turpitude, matter of Jimenez Cedillo from 2017. Just a little bit more before we go. Wouldn't you know it, that Mr. Legger's notice to appear was also deficient. And Mr. Legger did indeed urge the IJ and the BIA to terminate his removal proceedings for this reason, and he, quote, never argued that the defective notice to appear deprived the immigration judge of jurisdiction, end quote. Which is proper to do. The jurisdiction argument doesn't fly. It's a claims processing rule argument. Nevertheless, the BIA, as it has done to me and others that I know, misconstrued Mr. Legger's arguments on appeal as jurisdictional ones and then rejected the jurisdictional arguments that the BIA made up on appeal. But, explained the 11th Circuit, claims processing rules are not jurisdictional arguments, and the BIA can't do this. And so, having given up its opportunity to address the claims processing rule violation here, the 11th Circuit, quote, to aid the BIA on remand, offered the following thoughts, end quote. The 11th Circuit agreed with the 7th Circuit's big decision in De La Rosa from episode 127 that, quote, a non-citizen who raises a timely objection to a defective notice to appear is entitled to relief without also having to show prejudice from the defect, end quote. The BIA has come around to this as well, I believe, in matter of Fernandez. Although an IJ can permit DHS an opportunity to amend the defective NTA, I don't know how that's possible, given that there can only ever be one NTA at a time in a given case, and given that an I-261 can no longer amend a deficient NTA like this. A BIA amicus invitation is pending on this issue, so I guess the decision will be coming. The 11th Circuit went on to explain that the objection to the NTA must be timely, though. That means, quote, prior to the closing of pleadings before the immigration judge, end quote. But the advocate in me thinks that must be subject to equitable tolling under the right circumstances, right? Claims processing rules allow such things after all, as we have now all learned. Long one, I know, but can you blame me? And that is Legger v. U.S. Attorney General. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.